Okay, Wilberforce, can you tell us what's going on at the moment?
Alright, so I've just been given a letter from one of my sources, and it's a letter that is written by Lisa Blue and Company, which are the lawyers for the petitioner in this election petition before the Supreme Court. Now, this letter is dated the 18th of February 2021, and it's signed by Sonny Litter, and he addresses himself as solicitor for the petitioner. Now, it's entitled, it's actually written to the Chief Justice. So the letter is addressed to the Chief Justice, Judicial Service, Supreme Court Building, Accra. And it's entitled John Dramani Mahama versus the Electoral Commission and Nana Ekufuado, written number J1/5/2021. Now, the letter says that I received a call from the registrar of the court close to midnight, notifying me of respondents' filed affidavit in opposition to petitioner's application for review, soft copies of which he has sent to me by email at 11:13 p.m. I forwarded the proceedings to lead counsel for petitioner at 11:30 p.m. In order to allow lead counsel for petitioner reasonable time to factor the said affidavit into his argument in support of the application for review, I would respectfully request that this morning's proceedings be commenced at 11:30 instead of the scheduled 9:30. I count on your kind consideration of our request. And so this is Sonny Litter, who is writing to the Chief Justice asking that instead of the court sitting today at 9:30, because of some affidavit in the petition that has been filed late by the respondent, he wants proceedings to start 2 hours late, which will be 11:30.
Sorry, I don't know court processes, but I'd be interested. Is the fact that there's an opposition to their request to the justices, what has that got to do with what they're going to argue? Even if the respondent comes up with several arguments, how is that going to factor into what their petition is seeking to do? Can you explain that? Is there any thinking behind that? Is this a normal process again?
Alright, so I haven't cited the affidavit in opposition, but what I do know is that in our adversarial system, once you file, you are in court fighting with your adversary or battling it out with your adversary. You would always expect that when you file an application, they will file one in opposition. So once you file an affidavit in support of your case, you'd expect that your adversary will file an affidavit to oppose what you are saying. And so, to the best of my knowledge, the filing of the affidavit in opposition should not be new to the lawyers of the petitioner, or it shouldn't take them by surprise, because they should expect that the respondent will file an affidavit to oppose the demands that they are making.
Right.
However, this letter is essentially written to the Chief Justice and is actually asking that timelines should be shifted because they think that they want to read or give consideration to the affidavit in opposition that they received very late. It's actually entirely the duty of the Chief Justice to accept this or not to accept this.
Right.
Now we know that the court is supposed to sit at 9:30.
Okay.
We do not know if the time will be changed.
Right, so basically we have to wait and find out in the next 20 minutes where the justices will come and simply say, okay, we're adjourned till 11 because we got this letter, which they'd have to come at 9:30 to tell everybody and then go away again. Basically, that's what we're saying. And so far, based on the fact that the justices have been quite accommodating, it is likely that we'll have this delay.
Well, yes, so far they've been, perhaps the word used would be magnanimous to the petitioners in this matter, and that's because for every step of the way they have given them an opportunity to breach some rules. You remember the first time opportunity to amend their petition because they made a mistake. Another time, the court decided that instead of hearing the preliminary objection before the substantive case, we are not going to do that. We are going to hear it at the end of the matter.
Right.
Now, when they were asked to file their witness statement, they didn't file it based on the timelines that they've been given. The respondents, however, complied. Now, they came to court. They were given another window of opportunity, 24 hours, to file their witness statements, which they subsequently did. Now, even when it came to the witness statement, they filed two initially, and everybody was thinking that they were going to call two witnesses. After their second witness had testified and been discharged, they indicated that they had a third witness who, for health reasons, they were not able to get the witness statement. The court allowed it and allowed them to subsequently file adjourning for another 2 days. And so the court has treated them, quote unquote, with kid gloves. And we do not know whether it's going to happen again this time. You know that pending is the fact that the court has ordered that they should file their closing addresses. As it stands, that we don't know whether that has been done. Of course, we know that they filed a review application and also stay of proceedings. So we wait to see what will turn out in court today.
Okay, so we'll join you later on, and we'll be to find out exactly what does happen with this. But in anticipation, based on what we know, there's a likelihood that the justices will probably adjourn for the 2.5 hours required. Thanks very much, Wilberforce, and thanks for this update and this almost breaking news, as usual, from the Supreme Court. Thank you.
You're welcome.
Thank you. All right, so very, very quickly, because we don't know what's going to happen now, but like you heard me ask senior journalists out in the field, there's always this thing where you mentioned the number of times where the justices have made allowance in the interest perhaps of seeking justice to certain things that were not going quite right. I'm sorry to be hurrying you along, but I'm going to back to the issue that we were talking about beforehand. This is the whole Ayuni thing. And Elvis had spoken about it, and I'd asked a series of questions. I mean, depending on your memories now, Mr. Mahama, your thoughts on, the whole incident, and should he anticipate a punishment? Should the justices punish him?
Dr. Ayuni. I mean, another type comment. It's like the last time Enos of Seni made some comments out. My name was mentioned here, and his similar. I think that the comment was unfortunate. Dr. Ayeni.
You see, people love to use this word, unfortunate. I don't understand that.
Okay.
It was a mistake.
Unfortunate, it should not have been made. That's what I said.
Right.
It should not have been made. The comment should not have been made. Knowing who he is. And, when you decide to, I think that, let me make it short. I think my senior brother should speak as a lawyer when it comes to matters of law, and not as a politician. Yes, I know he's a politician, but when you are speaking on matters of law, your legal profession comes first, no matter what.
Would the justices be right to punish him?
Oh, that means if they feel that he has violated the code of ethics of the profession, why not? Especially when, what sent this man to court, our brother in 2013, to prison, contempt. What is the name? Ken Crunchy. What did he say? He said something on the petition, and landed him in jail for 10 days or so. Is it 2 weeks or 10 days? But this one, I know they have their own code of, if they feel that it has violated the professional code of ethics, why not? I think there are procedures how these matters are resolved. If they think that he has violated the code, I think every code, violation of every code has its own punishment.
The sanctions they go up
exactly, depending on what your conduct. So I think they'll be looking at all these things, but as I said, it should not have been said at all. Look, he even accused journalists of not being fair to the petitioner. Why? You held a press conference, journalists ask you a question, you will not answer a question, then you push the thing to journalists that you are not fair to. journalists force them to hold press conferences.